court draw near, for the court is now in session. The Honorable Justices Chad, Kenworthy, Leichty, and Carlson presiding. Be seated.
All Finally, William Brennan is a senior from Concord, New Hampshire. William is an English major with a minor in history. He lives in Delta Tau Delta and is the Rush Chair and undergraduate council representative for the fraternity. William is also student body treasurer, an enrollment ambassador, writing center consultant, member of the tennis team, and tutor to the First Plus Scholar. You might be receiving a theme: William wants to attend law school after Wabash, and ultimately become a public defender. William is thankful that the Moot Court experience has helped him become a vocal advocate. So congratulations to Andrew and William. Please join me in congratulating all of our partners.
I'd be honored to be.
It's my great pleasure to introduce our panel of distinguished judges. Serving as our Chief Justice tonight is the Honorable Damon, a judge of the United States District Court for the Northern District of Indiana and South Bend. The judge hails originally from Argus, Indiana. He graduated from Wabash in 1994, a member of Lambda Chi Alpha, and an English major. He received a master's in law and literature from the University of Aberdeen in Scotland. He received his law degree from Eisenhower, where he won the Moot Court competition. Before taking the bench, he practices as trial lawyer at Barnes and Thornburg, representing clients, especially manufacturers, in more than 30 federal and state jurisdictions across the nation. In addition to his judicial duties, Judge Leichty serves as an adjunct law professor at the University of Notre Dame. Please join me in welcoming him back home to law. Next on our panel is the Honorable Damon, a judge of the Indiana Court of Appeals in Indianapolis. Judge Kenworthy hails from Amboy, Indiana. She's a first-generation college graduate, having attended Ball State University. She earned her law degree from IU McKinney with highest honors, despite working and commuting while a law student. Before joining the Court of Appeals, Judge Kenworthy prosecuted hundreds of cases in Grant County, running the gamut from misdemeanors to murder. As a judge of the Grant Superior Court, she presided over hundreds of trials and established the award-winning Grant County Family Recovery Court to assist children in need of services families struggling with substance abuse disorders. Please join me in welcoming Judge Kenworthy to the law. Next is the Honorable Darren, Judge of the Montgomery Circuit Court here in Crawfordsville. A native of Newmarket, who in Montgomery County, Judge Chad graduated from Wabash in 1992, a member of Beta Theta Pi and a psych major. He took his law degree at IU McKinney, initially clerked for all three Montgomery County courts. He litigated with the firm in Carmel before helping open a firm in Crawfordsville, where he served clients throughout West Central Indiana in a wide variety of matters, including litigation, family law, criminal defense, and municipal law. The voters of this county elected him circuit court judge in November 2022. Judge, we're happy to have you come back to Wabash with us this evening. Thank you.
Thank you.
Our faculty judge tonight is Professor Matthew Carlson, chair of the philosophy department. Dr. Carlson originally hails from Monroe, Washington. He earned degrees in both philosophy and tuba performance at Overland. He jokes that he now uses his practical degree to learn philosophy. Dr. Carlson received his PhD from Indiana University. He teaches a wide variety of philosophy courses, but he's best known to many of the court participants as an effective and patient teacher of symbolic logic and a long-standing member of our pre-law committee, where he has strong
Good evening, Council. Mr. Kirkpatrick, Mr. Pirtle, are the petitioners ready to proceed this evening? I understand you have reserved 3 minutes for rebuttal. Is that correct? Yes, sir. All right. Who will begin this evening? I will. All right. And Mr. Dever, Mr. Grennan, are you both ready to proceed on behalf of the respondents? Yes, sir. All right. Very good. Mr. Kirkpatrick, you may proceed.
Chief Justice and your honors, may it please the court. My name is Seth Kirkpatrick, and I am joined along with my co-counsel, Mr. Gabriel Pirtle, representing the petitioners or state of red in today's case. The lower court erred in their decision to side with Net Choice LLC for 2 reasons. First, SB 7072 does not regulate the speech of social media platforms or conduct, which, applying the standards set out in Rumsfeld v. Fair, demonstrate that conduct is not expressive. And 2, even if this law did regulate speech, it passes intermediate scrutiny, demonstrating both a substantial government interest as well as a narrowly tailored law. Beginning with issue number 1, the cases utilized by the lower courts to side with Net Choice LLC have been used erroneously. They are simply too disanalogous to the case at hand to properly apply them in the same cookie-cutter manner that the lower court suggests. When it comes to Miami, there is a narrow amount of material being edited. The most important fact that separates this case from those used by the lower court is the temporal element. Social media platforms do not edit the original text of any user prior to that message being posted. They enact content moderation, conduct, censoring, and shadowing as examples.
Mr. Kirkpatrick, why can't a censored user create his or her own site as a conduit for speech? In other words, why isn't this just a geographical limitation on speech that these social media platforms are enacting rather than true censorship? You could develop a platform on the internet. It could be called Truth Social, Rumble, Gab, any number of other options, and reach the same ears of the world through these other venues. So why is this problematic in the start?
Yes, Your Honor. The reason this is problematic is because the social media platforms identified in SB 7072, Twitter, Facebook, Instagram, and so on, those companies have an immense amount of the market share, influence over politics, and they permeate every aspect of American life. Hundreds of millions of users posting hundreds of millions of posts every single day. To begin a new social media platform is difficult, as noted by the creation of Threads by Meta, demonstrating that even with a company such as that, beginning a new social media platform isn't always as successful as those that are currently most used.
I want to ask a different question. I'm puzzled by the temporal distinction that you draw between the Miami case and the case at hand. When I read the text of SB 7072, I don't see anything that seems to tell me about when the platform is supposed to be moderating content. So suppose the platform just changes their policy and they allow any post that is made, they moderate it before it is allowed to go live. Would there be a problem in that case?
There would not be a problem in that case, but that simply is not possible for the sheer quantity of accounts being provided to Twitter, Facebook, and other social media platforms. In fact, these companies employ an algorithm to handle this large quantity of posts. It is not the same kind of editorial review as found in a newspaper from a single city, from a state-run cable channel, or from a parade organizer.
I don't understand that. They're using an algorithm to moderate content. Couldn't they just use the algorithm before the content goes live?
Your Honor, the other point to this is not only the temporal component, but the fact that what they're doing is not editing in the same sense as Miami, Curly, as well as Turner. Their actions, such as censoring and shadow banning, are merely that, actions, conduct, which do not express anything to the users unless there is explanatory speech accompanied with it. When an account is censored, for example, there is a message that comes with it. This account has been removed. This is misinformation. This is incorrect. All of these conducts require
sorry. You were going to ask a question.
Sure, thank you.
Go ahead.
I guess I'm stumped by that a little, to the extent that these platforms select what messages go through, what messages don't, what they can say, what they can't. Isn't that conglomerate that they then send, isn't that their message? Aren't they sending a message through that?
No, Your Honor. As our clients report, there is no inherent message through those standards. They are more akin to a mall or a shopping center saying no shoes, no shirt, no service. There are merely standards and rules to moderate the kind of content that is found on their platform. However,
So, counsel, if you think that in this situation, the social media platforms are engaged in mere conduct and not speech, how do you then distinguish our holding in Turner with respect to the cable companies and the editorial discretion that they exercised in choosing stations to offer their customers? Would you not also call that then conduct instead of speech?
Your Honor, I would count that as speech because of one key distinction between Turner and the case at hand. In fact, Turner might be the most analogous out of any of the cases presented in the lower court, but there is still that temporal element. Even choosing which channels can have what stations, that cable company is making an editorialized decision of, do I allow CNN, do I allow Fox, do I allow channel A, B, or C? There is some level of editorial expectation prior to that channel being let out. There are also standards for those channels that they must follow to maintain their place within that network. So even in that instance, social media platforms once again remain disanalogous. There's simply too many posts being provided at once, none of which have been reviewed prior to their posting. And any of the conduct that is enacted does not change the actual message. That original message remains the same. The only thing that could be added is an addendum. But even if this case does relate to speech, there is a clear and substantial government interest backing SB 7072. The sheer force and power that these social media platforms have, the fact that 3 former presidents have used that platform not only for campaigning, but as official means of White House communication. There are world leaders conversing, constituents speaking to their people at a far larger degree than almost any other media platform this court has ever seen. There is simply too much of an overreach into American society and politics and democracy to ignore the weight that these social media platforms have. The law, too, itself is narrowly tailored. It only identifies those actions by social media companies that concern a substantial government interest. Additionally, the definition for which platforms are included has been narrowly tailored to the best of the ability of my client. It is including
If the social media platform posted an addendum to a post it found to be troublesome, either by way of misinformation or just functionally disagreement, would you agree that that addendum is the speech of the social media platform?
No, Your Honor. I would only consider the explanatory speech based off of the standard in FAIR. Even in FAIR, with the Solomon Amendment, a law school dean could not run into a recruiting session and shout down the military that is recruiting students.
But the social media platform is expressing a view, right? It's not mere conduct. They're actually posting and communicating a view. Why is that not functionally, just basically, logically, speech?
Your Honor, I see my time has concluded. May I respond?
You may.
It is not speech because it is residual of their conduct. It is an explanatory statement demonstrating what their conduct is. It removes any inherent message that could be found in the addendum otherwise. And for that reason, for the disanalogous use of cases, for the sheer weight and power social media companies have over our democracy, we respectfully request that this court overturn the decision of the lower court. Thank you.
Thank you, sir. Mr. Pirtle, good evening.
And may it please the court,
etc., that distance user speech from themselves, and they say in their terms and services that they do not endorse the user speech. Platforms have no legal liability for the things said on their apps. The platforms cannot both absolve themselves from things said on the app, and then claim that speech as their own to censor. The court extended the holding in Kenworthy and Fair by upholding a law requiring law schools to allow military recruiters on campus just like any other employer. The law school's hosting obligation only affected what the law schools had to do and not what they had to say. Similarly, SB 7072 only requires that platforms host all candidates and journalists and treat the rest of the public consistently. It is less intrusive than fair because the Solomon Amendment required that the law schools send emails or post notices to the employer's house to prove that the military had recruited them. The platforms are under no such obligation. Kenworthy and Fair should control here because the social media platforms host the speech of third-party content creators on their apps. As such, when SB 7072 regulates them, it is regulating conduct, not First Amendment protected speech. We know that the platforms act as hosts.
So, Mr. Pirtle, let's say we disagree with you. And let's say that we find that, as I was discussing with Mr. Kirkpatrick, that when the social media platform adds an addendum that they are speaking, seems rather commonsensical that they are. It's not mere conduct, they are actually speaking. Isn't there a problem with this statute in that it speaks specifically to barring that addendum? In other words, in defining censor, it includes adding an addendum. So it's not just the algorithm that might be used or other mechanisms that might be used, but the actual act of speech that the social media platform is using as an addendum.
Well, Your Honor, I would argue that the addendum provision is acceptable under FAIR because in FAIR, while the dean couldn't enter the recruiting session and shout down the meeting, and that's similar to how an addendum would work. Platforms can use addendums to vary messages under, or vary the third-party speech under those walls.
Perhaps we have a different understanding of what an addendum is. My understanding of an addendum is it's a piece of text added to something. I don't see how that amounts to burying it, like it would be analogous to shouting down someone's speech, making them unable to say something.
If there were no constraints on the amount or the type of addendums that the social media platforms could post, foreseeably they could use the addendums to further vary any of the content that they find disagreeable.
That happens in free speech all the time, though, right? I mean, the classic case or instance of free speech are two individuals in a park, one trying to shout down the other. That's the very essence of the First Amendment right? One can outvoice the other, but they can both voice their opinions. So why is that problematic here?
Even if the addendum provision is not acceptable under this standard, we would like to offer that it would be under the common carrier doctrine. So the common carrier doctrine applies to companies that hold themselves out to serve any member of the public without individualized bargaining, and the companies that are effective with the public interest, such that the firm's service play a central economic and social role in society. And we would argue that the social media platforms fit this bill perfectly. According to Pew Research, up to 50% of Americans use social media as a primary method for obtaining news and civic life, politics, etc. And they are also important in American economic life for journalists, academics, and others to post. And finally, brands also advertise and market their products through the platforms, and this is how the platforms have made their money. So it's important for the free speech of individuals that these platforms not be able to censor their speech.
Aren't common carriers even protected by the First Amendment, though?
They have reduced protections under the First Amendment.
And what is that level?
So I would say that the common carriers at the very least are not allowed to discriminate against certain groups. That's accepted by a long history from the idea that some persons are engaged in common callings and have a duty to serve. Supreme Court has held that they were not allowed to do this because they fit the common carrier doctrine.
Counsel, have these platforms ever been considered common carriers?
They have not been considered common carriers by the Supreme Court. However, the platforms have an effective monopoly over the niche of their online discourse. So for that reason, it's not like you can say that someone can go to a different site or a different website, because as Justice Thomas puts it, this is like telling a man he can hike the Oregon Trail after being kicked off the train. Each of the platforms has its own individualized and unique setup that makes it important for different aspects of our life. For example, Twitter is important in how we do politics these days. As my co-counsel mentioned, the past 3 U.S. presidents have had a Twitter account. The White House has a Twitter account.
Mr. Pirtle, it wasn't that long ago that I was a trial judge. And when conducting voir dire of jurors, asking jurors where they receive their news, in part because we're looking to explore whether they have some sort of bias that may pertain to the case or access to information that may pertain to the case, invariably jurors tell me, or once told me, I get my news from Facebook. I get my news from Twitter. It used to be they got their news from NBC or the New York Times or the Wall Street Journal, but now it's Facebook and Twitter. Does the reality of that fact help your common carrier argument or hurt it?
I think it would help our common carrier argument because, as you can see, the public is more and more turning to these platforms as the method for how they debate and civic life, or part of the voting body. And because of that, we have to protect those conduits of information. The platforms aren't speaking themselves; rather, they just provide the platform for the speech to occur.
Isn't the Telecommunications Act of 1996 instructive here?
Yes. So the Telecommunications Act of 1996 extended the common carrier doctrine to telegraph companies, and those are similar to the social media platforms at hand, because phones, when they came out, were important conduits of information as well. And it's bizarre to argue that much of the key communications infrastructure on which the social and economic life of the nation depends, and then yet to conclude that every communication transmitted through that infrastructure still implicates the platforms become the First Amendment evidence.
Mr. Pirtle, I'd like to go back a second. I've been thinking about something that you said. I'm puzzled by the claim that these companies, plural, have a monopoly. Isn't it the case that X and Facebook and YouTube and Instagram, forget Instagram, the first 3, isn't it the case that they're competitors with one another?
While they do compete in some ways, it is, as it was described in Biden Unite, the social media platforms have an effective monopoly over their own type of discourse. So yes, Instagram and Twitter, it would make sense for Donald Trump, if he was banned from Twitter, to then start posting about politics on Instagram, because it's not the same. It doesn't have the same. Niche that Twitter does in the politics. So when considered together, these social media platforms do have an effective monopoly on the way we transmit our news. And finally, the majority's arguments against the common carrier extension to the platforms do not hold weight. The majority argues that platforms are not already common carriers because they don't follow the same obligations and have terms and conditions. The terms and conditions don't exempt the firm from common carrier status. Rather, we have to look at whether the company offers the same terms and conditions to everyone, and the social media platforms do. They also argue that existing laws, such as Turner, has not regulated common carrier, has not regulated the platforms as common carriers, but nothing in Turner suggests that platforms couldn't be considered common carriers, as even the dissenters strongly suggested that cable operators could be regulated as common carriers under the First Amendment. And finally, they argue that federal law does not treat them as such, but this is not relevant to the case because no one is arguing that the Telecommunications Act of Congress is binding on the court. Social media platforms fit within the historical scope of the common carrier doctrine because they open their services to all members of the public under the same terms and conditions and are effective with the
Thank you, Mr. Pirtle. Mr. Dever. Good evening.
Good evening. Mr. Chief Justice, may it please the court. My name is Andrew Dever, and along with my co-counsel William Grennan, I will be representing the respondents, Net Choice LLC, in this case today. The lower court correctly held that social media platforms engage in First Amendment protected speech when they curate the content that they discriminate. SB 7072 impermissibly regulates content moderation tools including editing, shadow banning, deplatforming, and adding addendums. These are all forms of speech similar to editorial judgments found in Miami Herald with a newspaper company, and Hurley found with a parade organizer, and even cases such as Amazon and Coral Ridge. This is because these editorial judgments are speech that produce inherently expressive conduct. Coral Ridge gives us the standard that to determine if conduct is expressive, we would ask that whether a reasonable person would interpret this message or interpret it as some sort of message. And due to the nature of social media platforms such as Facebook and Twitter, everything that happens on that platform is speech, and therefore a reasonable observer would constitute a decision that we make, such as deplatforming or shadow banning or editing as such. Additionally, SB 7072 fails intermediate scrutiny because it is not narrowly drawn to furthering a substantial government interest. From O'Brien, we learned that narrow tailoring in this context means that the regulation must be no greater than is essential to the furtherance of the government's interest. This is not true in this case. Additionally, despite the contentions of the opposing counsel, there is not a substantial interest in this case because Miami Herald found that when the state argued that Miami Herald had a vast accumulation of unreviewable power in the modern media empires and that these conditions had resulted in bias and manipulative coverage, that this state rule trying to restrict the editorial judgments of the newspaper editors was still unconstitutional. That same principle still applies today. So this provision is so broad that it would prohibit us from removing hate speech if purported by a political judge or a political candidate, or even misinformation like inciting a riot or Islamophobia that comes from a state-run news source from another country due to that classification as a journalistic enterprise under SB 7072.
Mr. Dever, we address and answer constitutional questions based on the narrowest grounds possible. That's the role of the court. That's the prevailing wisdom. In light of that, didn't the district court here enter a preliminary injunction that was too broad? In other words, why shouldn't the court uphold the injunction as it concerns the definition of censor, because it addresses these addenda, what would be speech, let's say, by the social media platform, but otherwise leave the statute undisturbed as to anything else it might do vis-a-vis these social media platforms?
Because, Your Honor, the substantial interest that is being, or the alleged or purported substantial interest that is being furthered here is so broad and so all-encompassing that it doesn't differentiate between different types of editing, between editing versus deplatforming versus shadow banning. Social media platforms are making editorial judgments based off of their the platforms that their value hold, but those, as the opposing counsel stated, those types of editorial judgment are different in how they are applied, but they're all reflective on the principle of a platform exercising speech through the means of editorial judgment.
But aren't these social media platforms acting in a bifurcated way, in a dual way? In other words, when the social media platforms add an addendum, it's speech. But when they're hosting the speech of others, it is through their conduct that they act. So why shouldn't we address this statute as it concerns speech, their actual act of speech, but leave undisturbed the statute as it concerns their conduct?
Well, Your Honor, as we see it, both examples that you provided are actually speech. Delivering curated compilations of other speech was classified under Hurley as including a decision not to propound a particular point of view and thus speech. In addition, Bartnicki versus Vopper held that the dissemination of information is speech within the meaning of the First Amendment. So both the speech that you classified in your first example, as well as a carefully curated compilation of third-party speech through case law has been held as speech, and thus we would hold that an editorial judgment that we make, whether it is editing, shadow banning, deplatforming, those all still constitute speech, even if it's based off of the conduct or the content of a post from one of our users. We don't hold that every single thing that happens on our platform is speech. For example, a private DM between two users isn't speech on the part of our platform, but rather through when a person is coming and viewing a list of posts, for example, on Twitter or Facebook, that has been filtered through the algorithm and then reviewed by independent content moderators to basically make sure that it aligns with the platform's views.
I'm a little bit puzzled about shadow banning. In particular, I'm puzzled about the claim that it is inherently expressive. The expression shadow banning suggests that this is something that is done in a clandestine way, right? The users are not aware that this is happening. If that's right, how could it possibly express anything?
Well, Your Honor, there's two ways that shadow banning is inherently expressive. First, we can look to the legislation that SB 7072 puts forward, which lists shadow banning as one of the editorial discretion-esque features that is going to be banned under this. But they couldn't list that if they didn't know it was happening, right? And so they obviously understand this is happening. However, when we go back to the reasonable person standard of Coral Ridge, we see that there's many things that never apply on platforms such as Twitter or Facebook, and a reasonable person will understand that, for example, explicit material such as pornography would not appear on their feed because that is in contrast with the platform's views and thus censored through editorial discretion. When looking at other certain things such as hate speech, if a user is viewing a specific incendiary candidate, for example, and realizes that that person has posted incendiary or hateful speech and then sees less and less of that person's tweets or posts on Facebook, they would be reasonable in understanding that that might be because it is disaligned with the values that our platform holds.
Does it matter here that an algorithm is doing the screening and not a human? Does that matter under the law?
No, Your Honor, we would hold that it does not matter for two reasons. First, the algorithm being created by a human is implemented just to deal with the sheer quantity of information that a social media platform has posted on a forum every single second. But however, after an algorithm which is aligned with the platform's views and conditions is after it flags a post, it's reviewed by an independent associated with the company, but a human, a content moderation team, which determines whether or not that post is not only in alignment with the platform's values, but could cause potential damage or harm to the users of the platform as well as the public. We hold that part of our social media platform's responsibilities is to protect their users, and we have a civic duty to protect the people of the United States and of the world. And thus, when a content moderation team comes back and edits or deplatforms or shadow bans a specific post, they're acting in accordance with that. And so, while the algorithm helps humans with just the sheer quantity, ultimately humans make the final decision on that.
Would your answer? I'm sorry, Justice Kenworthy.
Just to follow up, the state of red suggests that timing matters. What do you say to that?
We would hold that principle is what's important here rather than timing, Your Honor. So in the cases of Miami Herald, Hurley, and Coral Ridge, each respective editor or parade organizer or a charitable foundation organizer makes decisions with what to include in their newspaper, parade, or list of charities based off principles that are inherently held by the members of the organization. we hold that social media platforms here are doing the same thing. When a social media platform creates an algorithm, it's looking for specific types of content that do not align with our values. And this is because we don't want speech that's permitted, or we don't want speech to appear on social media platforms such as Twitter that is then viewed by a reasonable person as being in accordance with our speech if it really is incendiary or hate speech, misinformation, for example, or inciting a riot.
Let me build on Justice Kenworthy's question, if I might. Suppose the algorithm and its development and its monitoring wasn't done by humans, but instead done by artificial intelligence, AI. Would your answer change?
No, I don't think it would, Your Honor, because the content moderation team would still have the last say in whether or not the posts that get taken down are not in accordance with the platform's values. Using a tool such as an algorithm within the process of helping humans,
So you would have the court extend First Amendment protections to artificial intelligence?
No, Your Honor, we would hold that this is still with the human element in both the creation of artificial intelligence and the creation of an algorithm, combined with the last step being initiated and reviewed by humans, that this would still be an editorial decision made by humans, even if a human is employing a tool such as an algorithm or an artificial intelligence, which is obviously not human in nature. So for these reasons, with the impermissible regulation of content moderation, which is inherently expressive speech and conduct under Coral Ridge, and the fact that SB 7072 fails intermediate scrutiny because it is not narrowly tailored to furthering a substantial government interest, an interest which treating a platform differently because it has power and bias has repeatedly been found by the Supreme Court to not be a substantial interest and thus be unconstitutional. We would hold that the platform, Your Honor, I see that my time has expired. May I continue? We would ask this court, we would ask this court to uphold the lower court's opinions, striking down SB 7072 as unconstitutional. Thank you.
Thank you, sir. Mr. Grennan? Good evening.
Good evening. Chief Justice, and may it please the court. My name is William Grennan, and along with my co-counsel, Andrew Dever, represent NetChoice LLC, respondent in this matter. I will be addressing the hosting and common carrier issues. The lower court correctly decided that State of Red's SB 7072 is a regulation of First Amendment protected speech and not a mere regulation of hosting for one principal reason: context. In Brown v. Louisiana, this court held that the innate context surrounding a sit-in by a group of African American students in a segregated library in Louisiana made the conduct of sitting down more expressive than it otherwise would be outside of that context. Similarly, NetChoice's social media platforms are in the business of disseminating speech, and within that context, the content moderation tools they employ to curate and disseminate third-party speech are expressive of the conduct that is welcome on the platform, the content that the platform recommends to a user, both of which are expressive and warrant First Amendment protection. SB 7072 impermissibly compels our client's speech because it interferes with the social media platform's ability to purport their desired message. In Hurley, this court held that a choice, quote, not to propound a particular point of view is presumed to lie beyond the government's power to control. Turner.
Counsel, I have a question. What is the social media company's desired point of view that they wish to communicate?
Your Honor, the social media platforms that NetChoice represents try to convey a lot of meanings, and Oftentimes, that's dependent on the user itself. The messaging that we want to put forth, or that the platforms want to put forth, is the reason why users come to these platforms in the first place, because of the content curation and dissemination and how those differ between social media platforms is what draws someone to a specific platform in the first place. So whether that message is this content is or isn't welcome on our platform, or if that message is this platform recommends this content for your consumption, both are expressive and warrant First Amendment protection. The Turner Court built upon the same underlying principle we see in Hurley, ruling, quote, by exercising editorial discretion over stations or which stations or programs to include, they, the cable operator, seek to communicate messages on a wide variety of topics and in many formats. The court there ruled that the must-carry provision, which is somewhat similar to SB 7072, quote, reduced the number of channels over which operators exercised unfettered control and therefore triggered First Amendment scrutiny.
Mr. Brennan, I'm struggling to see why these social media platforms aren't common carriers, and this builds on what you've been arguing. Suppose AT&T, you agree, let's start with this. You agree with me that the telephone companies are part of a group of common carriers, right?
Yes, Your Honor.
All right, so suppose AT&T added to its contract that it will curate content, particularly when its data lines are being used. And so if its data lines are being used, say for the presentation of Republican ideas on a Zoom presentation, so more to the masses, or if it's a view on Black Lives Matter, or you know, if it's Palestinian or an Israeli. If the phone companies said and added to its terms that it would curate content, would that change your view as to whether that phone company is a common carrier?
Your Honor, I think it would. A critical distinction in where the court has applied common carrier criteria has been in the amount of control they exercise over the content that they're disseminating. In the case of railroads, someone goes to buy a ticket to come from Indiana to San Francisco or something. They agree to the terms of paying for a ticket to go where they want to go. When you engage with a social media platform, you're agreeing to give that third-party speech over to the platform to be curated and then disseminated. But there is no guarantee that that content is going to reach the audience that you so choose. And in that way, social media platforms are making individualized decisions.
But our cases, when it comes to the common carrier doctrine, were never based on whether there was a contract, whether there were terms and conditions that the user understood that the common carrier would curate content. It was based on other considerations. How is what the social media platform is doing any different to my hypothetical with respect to a phone company that we've recognized as a common carrier?
Your Honor, I can't speak to the specific content curation that would be happening in this hypothetical, but the pertinent test when it comes to common carriers in the communication field comes from FCC v. Midwest Video Corp. And is a business could be considered a common carrier if they don't, quote, make individualized decisions in particular cases whether and on what terms to deal. State of Red seemingly believes that these social media platforms are making individualized decisions in particular cases and applying different terms to those cases. They have purported that there's a liberal bias going on that they need to protect their constituents from, which would indicate that our social media platforms are making individualized decisions, albeit ones they don't like, in particular cases, and thus it does not fall consistently within the guidelines of how the court and state legislatures have bestowed common carrier status upon.
Didn't Western Union do the very same thing back in the day? Western Union was making decisions about whether it would allow its telegraph to dispatch political messages or messages that was contra the Associated Press, right? Why is this any different than the telegraph of old, which at that time was the modern technology?
Your Honor, in Western Union, the telephone company only had control over whether you could use the service if you could use the service that you've entered into a term to use. So in the case of a telephone, they can only control if you are or can't dial out of your home line, as opposed to what's going on here with social media platforms. The dissemination of this third-party speech only happens through these editorial decisions that our clients are making. It's the same thing as a postage person delivering mail. Postage workers or postage companies have been subjected to common carrier designation in the past, and someone delivering that mail isn't determining where it's going. They are bringing it from point A to point B, but in this case, the curation and dissemination of speech is intentional, and it's putting content in front of users based on who the platform thinks would enjoy consuming that content. And so in that way, social media platforms are much more involved in the actual facilitation of communication than a simple telephone company. I would say the comparison to the telephone company is a bit more analogous to an internet provider as opposed to a social media platform. The Telecommunications Act of 1996 differentiates interactive computer services from common carriers or telecommunications companies, and the Act explicitly protects internet companies' ability to restrict access to a plethora of materials that they might consider objectionable. That is fundamentally at odds and inconsistent with the common carrier obligation to hold oneself out to the public indiscriminately. Platforms make choices about how and to what degree speech is disseminated to users in a discriminatory manner. If you are a user with 5 million followers, that speech is going to be disseminated in a much different way than a user with no followers. And in that sense, our platforms are making individualized determinations in particular cases, whether and on what deals to on what terms to deal. In Turner,
I have a question. I'm having a little trouble following your argument, so I'm going to give you an argument, and I want you to tell me where I'm going wrong. This is what I think you're saying. A company is currently under common carrier obligations. They no longer wish to be so. Here's how they escape. Start discriminating against the content that they carry. In that case, they are no longer subject to common carrier obligations because they are now making editorial decisions. If that's right, isn't the common carrier doctrine toothless?
Your Honor, I mean to put forth the idea that platforms integral to the functioning of these platforms is editorial discretion in where the content is coming from and where it is going. And that is at fundamental odds with the common carrier criteria that have dubbed entities common carriers in the past. And I will note that social media platforms have never fallen within the purview of common carrier criteria. Not to say that couldn't happen in the future, but the precedent isn't there at the moment. The Turner Court declined to analogize cable operators to electricity providers, trucking companies, and railroads.
Your colleague argued that these social media platforms that you represent perform a civic duty. You agree with that?
No, Your Honor.
You don't agree with your colleague?
I do not.
Why? You
I see
agree
my-
you said that?
Yeah, I see my time has expired. May I conclude?
Oh, you can definitely answer this question.
As a private entity, social media companies choose the nature of the dissemination and curation of speech, and they do so for their own private interests, bringing more users to their platforms. When I think of a civic duty, I don't necessarily see business decisions as being the motivation behind something like how we're curating and disseminating speech. We respect.
Are they not serving the public weal?
Your
Are they not
Honor,
serving the public good, the public interest in facilitating the communication of all this speech across the country and throughout the world?
Your Honor, that is certainly an aspect of the product that our social media platforms provide, but it isn't the fundamental motivation behind things like their content curation and dissemination. We respectfully ask that the court uphold the lower court decision and protect NetChoice LLC's freedom of speech.
Thank you, Mr. Grinnan. Mr. Kirkpatrick, rebuttal.
Thank you, Your Honor. May I proceed?
You may.
Chief Justice and Your Honors, and may it please the court. NetChoice LLC's defense places social media companies in a kind of paradoxical situation with the First Amendment. Justice Kenworthy, I believe you had asked my co-counsel about the Telecommunications Act of 1996. There is a component to this act that our client feels necessary to include. As part of that act, there was also the Communication Decency Act attached to it. For the last 25 years, social media companies have operated under this legal approach. Quote, no provider of an interactive computer service shall be treated as the publisher or speaker of information provided by another information content provider. As it stands here, social media companies not only, through their own terms and service, say we do not endorse the speech of our users, their speech is not our speech. Not only does it stand currently through federal law that their speech of their users is not their speech, but we also have our friends on the opposing counsel positing the argument that almost
Mr. Kirkpatrick,
everything.
Before you move on from the Communications Decency Act, let me ask you, since you seem to be embracing that law, and I apologize if this is an unfair question this evening, but that law also provides an exemption to social media platforms if they act in good faith in deciding what is frivolous or filthy or obscene or otherwise objectionable. It has that provision in the law. If federal law says there's nothing wrong with the social media platforms doing what they're doing so long as they act in good faith, why is it okay for the red state to say that it isn't?
Your Honor, it is okay for the red state to say it isn't because of the interest they have in the power of social media companies. As it stands now, granted this law was created 25 years ago, the situation today is noticeably different. But what matters about this act is the fact that it is still on the books. At the same time as these companies are saying this is not our speech, they also say it is all of our speech as soon as a state attempts to regulate their conduct. Now, these companies can act in good faith when regulating. This law only purports the similar principles of consistency and permitting political candidates and journalistic enterprises to be on their ever-reaching and permeating powers of platforms.
Mr. Kirkpatrick, I noted that consistency is not defined in SB 7072. Why can't it be consistent simply to endorse one's terms of service for everybody? Why isn't that enough for consistency?
Your Honor, I see my time has concluded. May I respond?
You may.
The law purports consistency because even though those terms of service may be applied to every user, there are instances wherein political candidates and journalistic enterprises have been unfairly discriminated against on these platforms. That distinction is key. When the presidents, world leaders, the White House
constituents utilize social media platforms to this degree, to have them also be able to discriminate against certain candidates is not only threatening for our society, but for our forms of democracy. And for that reason, we respectfully request that this court overturn the decision of the lower court. Thank you.
Thank you, sir. All right, thank you, counsel, on all sides. We will take the matter under advisement and adjourn.
All rise. All rise.
You all may be seated. Thank you. All right. Very nice job, counsel. I'm going to turn it to my colleagues here first to share some comments with the group. And once we've all had an opportunity to share comments, we'll announce who the panel believed to be the top orator and advocate this evening. But I'll start with our justice on the end here.
Yeah, thank you. I'll just share some general comments with the four of you as a whole, I guess. First, I was really impressed with all four of you. I mean, this is a really impressive group, a really impressive program. To get up here on this stage and do this is a really great thing to be able to do, and you all four of you pulled it off like you've been up here 100 times, and I know you probably haven't. When I think moot court, and it's been a long time since I've been involved in moot court, but when I think about moot court, I always think the most important thing you can do to be prepared for something like this is to be over-prepared on both the facts and the law. I've always told moot court folks, if you know the facts forward and backward, and you know the law applicable to the case, you're not going to get too stumped up here at the mic. You might face a tricky question, you might get thrown for a loop on something difficult, but you can always come back to knowing the facts and the law, and I think all of you did that. That's the first step and probably the biggest step. Aside from that, I think all of you showed great confidence, great poise, great interaction with the four of us, appropriate deference, but also standing up for your positions when you needed to. I was impressed by all of them. Great job to all of you.
So I will agree with my colleague here that I'm impressed with each and every one of you. And then I'll just say a few individual things to each of you. First of all, Seth, I thought your comeback was really good, your rebuttal. You did a nice job of picking out a question that maybe didn't go as well with your partner. And so you cleaned that up on rebuttal, and that's exactly what you should be doing. And you also responded to some things that these guys said during their argument. So that tells me that you have a skill right now that a lot of young lawyers don't have, and that is to actually listen to what's being said in the courtroom. And not just reading from your outline, because things don't always go as you think it will on your outline. So clearly you had mastery over the topic, and you were able to keep your ears open at the same time, and that's a real skill set. Gabriel, I felt like nerves got you a little bit. On the other hand, you also had a good interaction with all of us. You listened carefully to the questions, and you answered the questions directly. So you didn't try to skate around a question. I think a couple of them tripped you up just a little bit, but your partner was there to catch you on a couple of those. You have a good demeanor when you're talking, easygoing demeanor with the judges, so that's important. William, I understand you go by Liam, right? Okay. So at the beginning, I noticed that you were reading. And so the advice I would give you is to get ready for your opening. Make sure it's solid and ready to go, because that gives you confidence for what comes after. So if you can start strong and end strong, then the stuff in the middle sorts itself out. So that would be my advice for you. But you pivot very well. So you had some challenges from my colleagues here, and they didn't let you off the hook, and you hung in there and stuck with it. And Andrew, I feel like you have a very easygoing demeanor in the courtroom, and that would suit you well if you want to do trial work, because I think juries would really connect with you as a person. Great eye contact. I thought your answer, I think it was about shadow banning. I thought you did a great job of answering that immediately, directly, and there was a two-part answer to that, which I thought was impressive. So across the board, great mastery of the topic, and we stepped back here and said, I can't believe they're not in law school. So great job to all of you.
Yes, I will echo all of those comments. I agree. I will add a few remarks of my own. So first of all, this is a complicated case, and I was very impressed with all of you in having a very solid understanding of the details and the nuances of the complexities that you were discussing. And this came out particularly well in your responses to questions. I was particularly impressed by the ways in which you handled questions from us. It's one thing to be prepared and ready to talk. It's another thing to be able to think on your feet. And you all clearly did a very nice job of that. So, yeah, when we were back in the room, not only did we say, I can't believe they're not in law school, it was, boy, this is a hard decision, right? You all did an excellent job.
Thank you. I'll echo what my colleagues have already said. You all did a tremendous job. Just take a moment and pause here. This case is going to be argued in front of the United States Supreme Court here next spring, right? You are arguing the same case in many ways. It's going to be argued in front of our highest court. And that really does give you a sense of scale and depth when it comes to a legal problem like this. In addition, as I listened to you advocate, I sort of lost track of where I was. I remember Wabash all too well. It shouldn't surprise me that you have the skill set that you do, because the school prepares you so tremendously well. But I could have sworn you were law students. I could have sworn you were beginning your career as young lawyers. You were just that tremendous in navigating through the law and the facts and handling some tough questions along the way. Justice Marshall said that listening is just as powerful a means of communication as speaking. And every one of you displayed that really rare art. And sometimes this is very rare even with the most seasoned lawyers, of listening to a judge's question and really trying to understand and suss out why the judge wants to get that question answered to help him or her decide a case. And that's difficult, even, like I said, with the most seasoned lawyers, and you all were doing that as you were this evening. So I was just tremendously proud, frankly, to watch all four of you in action, and this tells me that Wabash hasn't lost its touch. So thank you to my colleagues for the comments. I think the only other news that we need to announce is the top advocate, and though the panel believed that every one of you did a tremendous job, our vote is for Seth Kirkpatrick.
We have another prize that we would like to award at this time. The Floyd Artful Advocacy Prize honors the memory of Douglas B. Floyd. a Hamilton County lawyer, remembered by his colleagues as an artful advocate of causes he believed in. The winner is to be not only a successful advocate, but also kind, tactful, and principled. As lawyers might say, he succeeds without scorching the earth. What we seek with this award is not only winning qualities as an advocate, but also a winning disposition, someone who can take the heat with a smile. Funded by gifts from Doug's colleagues, friends, and family, given at the time of his untimely death in 2001, Doug's wife, Lisa Floyd, and his son, Riley Floyd, Wabash class of 2013, established the prize in 2019. Selection is made by the faculty members who organize Moot Court, and the award may go to any of the 4 Moot Court finalists. On behalf of myself and Dr. Drury, we are very happy to award the Floyd Artful Advocacy Prize for this year to Mr. Andrew Dever. Would you please join me in thanking our panel of judges? We will be presenting each of them with a gavel to mark their participation with us this evening. We're truly grateful that you've made this educational opportunity available to our students. Thanks very much for doing so. Dr. Drury has already made our thanks to many people who are necessary for this program to operate. At this point, I just want to invite all of you to join us in a reception in the Littell lobby, which is right outside the doors in the back. But first, I would ask anyone present who participated as a judge or advocate at any stage of the competition, would you please join us on stage now, along with our judges, along with our finalists, for a photograph. And with that, we bid you a very pleasant good night.